India's cybercrime bail paradox, why Supreme Court rhetoric signals a coming digital rights collision. The old approach just got more expensive. The practical edge now comes from changing process, timing, and tooling together. We will map trigger, incentive shift, and downstream impact before the close. On June 16, the Supreme Court called cybercriminals parasites on the digital economy, and explicitly asked Parliament for sterner preventive detention laws. This isn't judicial restraint, it's a legislative roadmap, and it's already being drafted. Within 48 hours, 3 separate legal policy groups confirmed the Ministry of Home Affairs is circulating amendments that would make certain cybercrimes non-bailable by default. We're talking phishing operations over 50 lakh rupees, SIM-swap fraud chains, organized digital extortion, all eligible for preventive detention up to 12 months without charge under a proposed Digital Security Act 2026. Here's the scale problem that triggered this. India's National Cybercrime Reporting Portal logged 8.7 million complaints in 2025, that's up 340% from 2023. But the conviction rate is just 2.1%. For context, murder convictions are 47%, theft is 31%. The system is drowning, and courts are now treating digital fraud like an existential threat rather than white-collar crime. But here's what nobody's talking about: the collateral damage happening right now to 4.2 million Indians who work in business process outsourcing and fintech back-office roles. The line between IT services employee and cybercrime accomplice is becoming legally impossible to defend. Take the case that triggered the June 16 ruling. The accused worked for what looked like a legitimate customer service outsourcing firm in Gurugram, processing refund requests. The prosecution says the entire operation was a phishing front. The defense says employees believed they worked for a licensed BPO, processed real refunds, had no knowledge of upstream fraud coordination. So who's criminally liable, the person at the keyboard, the manager who hired them, the firm owner, or the client who contracted them? The courts are already answering. The Mumbai High Court denied bail in 73% of organized cyber fraud cases this year through May, compared to 41% in 2024. Defense attorneys report judges citing the volume of digital evidence, entire terabytes of transaction logs, as presumptive proof that accused parties could digitally tamper with witnesses if released. That's not traditional criminal logic. That's treating digital volume as guilt itself. Here's where this gets geopolitically serious. India has mutual legal assistance treaties with 47 countries, but no specific cyber extradition frameworks. If India reclassifies cyberfraud as terrorism adjacent, and the Supreme Court's parasite language echoes exactly that terrorism-era judicial tone from 2008, it triggers 3 things simultaneously: fast-track extradition under existing terrorism treaties, asset freeze coordination with US FinCEN and EU financial intelligence units, and visa revocation for anyone charged, not convicted, with organized digital fraud. The US-India Tech Council held a closed-door session on June 14, 2 days before the Supreme Court ruling, specifically about mutual concerns over cyber prosecution overreach. Translation: American companies are terrified about their H-1B visa holders in India being retroactively charged if their previous employers are later deemed fraud fronts. So what actually happens next? 3 scenarios are playing out in real time. Scenario A: Parliament narrows the amendments to only kingpin coordinating roles, requires judicial review within 48 hours, creates safe harbors for downstream employees. Conviction rates improve to double digits, fraud losses plateau. Probability, 30%. Scenario B: Preventive detention applies to anyone in the digital chain of custody. False positives spike, BPO sector hemorrhages talent to UAE and Singapore. Insurance costs make Indian fintech 15 to 20% less competitive than Southeast Asia. By 2027, we see the first wrongful detention lawsuits hit international arbitration. Probability, 50%. Scenario C: Civil liberties groups challenge these provisions under Article 21 of the Constitution. Supreme Court splits 3-2. Parliament invokes rarely used Article 31C to shield legislation from fundamental rights review. India's digital economy faces 6 to 12 months of regulatory limbo, spooking $8 to $12 billion in pending VC commitments. Probability, 20%. Now, the opportunity layer. Every crisis builds the next generation of infrastructure. Legal tech companies that can prove employee, clean corridors, using blockchain-verified role segregation, real-time compliance monitoring for BPOs before fraudulent client onboarding, bail-as-a-service platforms with predictive analytics on release probability, these are the winners. A Bangalore startup called Nyaya.ai just raised $14 million in Series A on June 10 specifically to build digital crime defense automation. The founder told TechCrunch every BPO will need a legal co-pilot within 18 months, or they're uninsurable. But here's the human cost that matters most. The Supreme Court's word choice, parasite, isn't neutral. It dehumanizes. It echoes colonial-era criminal tribe designations and emergency-era antisocial elements rhetoric. And every time courts use biological threat language, procedural protections erode fast. Between January and May 2026, the average pre-trial detention for cyber fraud accused in metropolitan courts was 347 days. That's longer than for assault, 121 days, or robbery, 198 days. Many detained are first-time offenders, young men from Tier 2 cities who took data entry jobs that turned out to be phishing scripts they didn't understand they were reading. The real question isn't whether fraud should be punished. It absolutely should. The question is whether India's legal system can build gradations of culpability in an industry where a customer service rep might genuinely not know they're part of a crime. Because right now, the Supreme Court is signaling it won't bother. The next 90 days will determine if this becomes a precision tool that finally brings cyber conviction rates into double digits, or a dragnet that criminalizes technological ignorance at scale. Either way, parasite signals courts are done treating digital fraud as white-collar crime. They're treating it as existential threat. And that changes everything, from BPO hiring practices to venture capital term sheets to whether young Indians will even take tech jobs anymore. This is worth paying close attention to. India's Supreme Court just called cybercriminals parasites and demanded preventive detention laws. Within 48 hours, the Home Ministry started circulating draft amendments that could lock people up for 12 months without charge for phishing over 50 lakh.